Right. ADA. ADA is one of the few laws that transcends both the employment side and the spectator side. So we covered previously, issues with spectators, but we didn't really look at like there's legislation that might protect them. And the ADA says that if you are a participant, you're entitled to rights. If you are a spectator, you're entitled to rights. If it is a public assembly facility, which is open to the public, it's by its very nature. So part of the ADA says, look, you have to have line of sight. So if you're a disabled person in a wheelchair, you should have a viewing area at all key price points that you can see the action and be able to be integrated in the most integrated manner possible. There's also, if you're a participant, that they have to provide opportunities that are reasonable and safe for people to participate in the most integrated manner possible. Now, this can lead to a lot of issues, like if you have a race and you have people in a wheelchair division running at the same time as people who are able-bodied running, because that could be tripping hazards and stuff like that. But that's part of the ADA. What we're going to focus in on right now is we're covering that area a little bit more under the other modules, like under the youth law. There's an ADA case involving a third base coach for Little League. So we'll cover that stuff later on. But let's just look at the employment side. The employment side of the ADA says if you're an employer with more than 15 employees, so remember they don't want to hurt the small little guys, if you have someone who is disabled, that you're supposed to provide them with reasonable accommodation. And this is something that you really want to highlight in any employee manual is what is that reasonable accommodation? Well, the first question though is what is disabled? Under the ADA, they're very clear that disability is someone who has a medical condition, someone who is perceived as having a medical condition, someone who has a relationship with someone who is medically qualified as being disabled. So there's a couple key areas here. So would you say that anyone here is left-handed in the room? Okay, so we have 3 left-handed people. Are you guys disabled? Well, why not? You know, left-handed people just don't have the same kind of coordination as right-handed people because not as much gear is made for left-handed people. It's made more for right-handed, right? So maybe you guys are disabled. How about, do we have anyone who's blonde here in the classroom? All right. So is that a disability? You're saying, yeah, it's obviously you're disabled. I mean, where do we draw the line? So how about if someone has dwarfism? Are they disabled? If you ask them, they're saying, I could do anything you could do. And they probably could. But how are we going to look at them? People are probably looking at them and saying, oh, I feel so bad for you. And they feel a given way. And that's being perceived as disabled. If you have a cosmetic injury, if you're born with birth defects, all these different things. So if you have major birthmarks maybe, people might say, well, oh boy, I feel so sorry for you. So we're always trying to take a look at what is this disability. Also, if you have a relationship. So let's say you live at home with your parents because your parents are elderly and you have to provide assistance and care for them because they have medical conditions. You're covered by the ADA. So if you go to your employer and say, look my parents have X disease. All I need is to be able to go one afternoon a week, an hour earlier from work, to go and take them to the hospital. I'll make up that hour earlier that day, but this is what I need. The courts will say that's reasonable. And if an employer says no, then they're probably violating the terms of the American Disabilities Act. All we're always looking for with ADA is what is reasonable to allow people to live their lives and not be handicapped by the fact that they are disabled in a given way. And so it doesn't mean everything needs to be provided. It only means what is reasonable. So they'll take a look at what is the cost for some of the expected repairs or modifications, and almost all of them can be done for under $500. If they're saying, hey, we need to install a new elevator or tear down the building and build from new, no, that's not what is required. So this is one of the first laws, the ADA and then the ADEA, which started impacting white Americans. Because before that, they didn't have really a lot of issues that they had to face in terms of discrimination. Now, if you're, let's say, 60 years old, you're Caucasian, you're diabetic, you might have a couple different things that you could be discriminated against for. One might be the disability, because you're diabetic, which is considered disability. Even though you can maintain it, it's still considered disability. And you're over age 40, so you're older. So those are the kind of things that people will start taking a look at, which in the past might not have been an issue for them. If we go, let me just quickly go through some of these other ones. Title IX, we all think about that in terms of programs. And we're going to cover that in the college program area. But it also affects employment, that if you complain about a condition of employment because you think that they aren't providing appropriate funds. Now remember, Title IX does not mean you have to give preference to women over men. It means you can't give any preference to one gender over another in what you're doing, and you're supposed to have equal allocation of funds. So this applies to employment as well, that, are there too many male coaches coaching women's sports? Well, can you say, okay, we're going to get rid of the men's coaches? Well, that could be like reverse discrimination. It is who is qualified and things like that they have to take a look at. But if you are a coach, and the Jackson case was an African American male coach who complained about the treatment of his female athletes, and he was terminated, he was able to get damages and his job back through the United States Supreme Court. But they said, yes, you're entitled to individual damages under Title IX. Equal Pay Act is a very specific area that if you do equal work, equal job, equal responsibility, not equal title, but everything else is equal, should you be paid the same? So how about a Division I men's basketball coach that's male and a Division I women's basketball coach who's female? Should they get paid the same amount? And we can take a look at UConn as an example. So Gino versus, who's the men's coach now? Okay. So, should they be paid the same? Should he be paid the same?
I feel like that's kind of a, I don't really know if you could use that example because there's so many other factors. But should they be discriminated on pay based on their sex? No. But should they be paid the same? Probably not either, because there's different factors that play into a coach's salary, like record and I don't know, support and things like that that play into it.
Let's say, given all the other variables that you're talking about, two brand new coaches, one men, one's women. And that's it, Division I, should be paid the same.
Theoretically, yes.
How about you guys? Come on, don't just leave her hanging there.
In a perfect world.
I think it comes down to potential of earnings generated by that person. If your female team averages 500 fans a game and your male team averages 3,000 a game, they're bringing in more. The men are bringing in more money, so therefore that might generate more pay for the coach. Same thing the other way around. If the female team's like a UConn, where they're filling every arena they play in, then maybe the female coach gets paid more if the men's team's doing poorly. Especially with like a football team at UConn that doesn't do as well. And then Gino Auriemma, who's a very successful women's basketball coach, he may be worth more in that sense.
Okay. Would your answer change if it was like Division II or Division III? And in fact, that's how the courts look at it, that Division II and Division III is significantly different. In the Stanley case, what happened there is she was a national champion coach at USC, and she won with Cheryl Miller as one of her players, and she won the national championship. And she basically said, look I'm at a major D1 program. I should get paid the same as the men's basketball coach. And the court concluded, no, you shouldn't. The men's program has more responsibility, more exposure in the media, harder recruiting issues because they're recruiting against all these other major programs and you don't have as much recruiting. So basically they took a look at the entirety of it, but the court basically came down and said, look if this was a Division II or Division III program where they're very similar, where they don't have the same media and revenue issues, that then probably they should be paid about the same. And so it's an interesting area because if you look at their jobs, they're both recruiting, they're both training people, they're both coaching the games, all that kind of stuff. That's basically about the same at Division II, Division III.